All right, welcome back to another edition of the Dirty Verdict Podcast. I'm one of your hosts, Peter Taaffe, joined by
the second best host, Bill Ogden.
And we're again missing our friend, comrade, Kyle Herbert. No telling where he is. Hopefully we're at his office. So
I think he said he was going to a Communist Party rally or something. So
yeah, something unsanctioned.
Pretty sure that's what he said.
But hey, we were able to secure a pretty A-list replacement to join us, and that is Will Moye. Thanks for joining us, Will.
The Dwayne "The Rock" Johnson of the Dirty Verdict Podcast, Will Moye.
So
to be back.
So Will, we're going to talk to Will about one of those housing, how it started, how's it going themes for his life as a plaintiff's lawyer that he'll share with us a recent verdict. But before we get into that, we're going to be joined by a special guest, Herrick Sovany. Thanks for joining us, Herrick.
Thanks for having me.
Clap, 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 clap. Herrick's a lawyer here in Houston. I first got to know him because, at least at the time, my firm, when we get medical malpractice calls, we elected not to handle those, but to refer them to people that knew what they were doing, and Herrick was one of them. So that's how we first got to know each other. And now I'm obviously out of that line of work. So, but Herrick, you also are doing different stuff now too. Is that right?
I am. We still do a little bit of med mal, but we try to stay away from it.
And why is that? Just to talk about the elephant in the room.
Well, for those who haven't done it, they know Chapter 74 is a minefield. Every step of the way, before you can start discovery, you've got to go through the expert reports, and then you have to sort of pray to God that they don't file a motion to dismiss. And if the court doesn't grant it, there's an interlocutory appeal. So you're looking at, all of a sudden, months before you can actually start real discovery. It's expensive, and quite frankly, the court systems, you can't get a trial setting. So once you have all of your ducks lined up, you favor your experts, everything's good to go, you're still holding on to the expenses and waiting on a trial setting. You do really well, you get capped. So it's implied.
And let's clarify. So there's caps on damages in med mal, and to me, that's probably the biggest hurdle, right?
Well, it's the biggest deterrent, I think, that a lot of lawyers see with regard to whether they want to dive into med mal or not, without knowing the technicalities of everything that goes into it, like the expert reports, which are key.
Yeah.
Because if it gets granted, your case is dismissed with prejudice.
And so you've got to have a report. It's got to be very specific about all the elements, causation, et cetera, and it's got to be filed or served within how long after the lawsuit's filed?
Within 120 days from the date of the answer.
And then can you get some kind of extension, or is it very hard?
Very hard, or by agreement.
Yeah.
You defense lawyers will agree. But
okay. And then their first and their playback book is usually to file a motion to dismiss for the report doesn't meet this standard or what have you.
It is. It used to be standard practice because the defense bar would think, and we've talked to several of, on the defense side, if they didn't file a motion to dismiss, they would consider it malpractice. So they, by default, would file a motion to dismiss until recent cases, I think it's probably now 4 years ago, where they started coming out and the appellate courts were saying enough's enough.
Who's your least favorite med mal defense lawyer? Let's just throw it out there.
Least favorite?
You don't have to answer that.
Unless you want to. I would love it, but you don't have to. But that's who they are.
Our last guest gleefully announced who their defense counsel was on their trial. They didn't. I didn't have a chance to admonish them that that's.
Yeah, who defended? They were like, best case scenario, Jeff.
Yeah, you have to say that, but no, it's a small bar on the defense side. These Will, I don't think you've handled any of those, did you?
Our firm would handle a little bit of nursing home malpractice, if that was about it. Actually, we've got colleagues that handle a lot more veterinarian malpractice than doctor malpractice in my old shop. Does that fly under 74? No, I think that's why they're not filing it. It's really a dog when it's your aunt. Well, yeah, med mal is definitely in the news right now, I think. And I'm not sure if it is med mal or not, but with the Memorial Hermann transplant unit getting shut down, and then it looks like in the last 48 hours, Philadelphia shut theirs down too for the same issue, and the FBI is raiding hospitals. So, do you have an opinion on does that fall under the med-mal caps?
Which one? The veterinary?
No, the Memorial Hermann transplant unit, and it was in the Chronicle. I read about it, but the head was changing criteria to an impossible. It was like for this one you have to be a 9-year-old, a 300-pound 9-year-old. It's like, well, those don't exist, and so they were doing it to get other people in, and it's got 38 deaths confirmed, at least from Memorial Hermann right now.
I think it would fall under it, and to gamble and not file it under Chapter 74 would just be asking for trouble.
It's an easy report to write. I mean, that's got to be beyond this.
I agree. Yeah, but it's less on the Chapter 74 triggers on the reports, more on the caps.
With regard to Memorial Hermann, what's interesting is it has to be affiliated with an institution, and they're affiliated with UT. So now you've got the Tort Claims Act that kicks in whenever you're dealing with Memorial Hermann on the Med Center. So now you got two sets of
problem hurdles. Yeah, or two different caps. Notice out to be able to bring that claim
within 6 months.
So what happens if you don't discover what the criteria was? Is there a discovery rule on that 6-month TCA?
Not on the Texas Tort Claims Act.
That's a damn shame. I know Sean Tracy, Sean Fox, and Lance Walters have a few now of the deaths, and I know Davis and Davis had a press conference today, about it as well. So I'm very interesting.
Did they, Amanda?
Yeah, so Davis and Davis apparently have great taste in hiring PR people because they hired Amanda Orr, and she's the only reason why we have not been canceled yet.
And let's thank our hosts, our facilitators, Amanda Orr Strategy Group, Josh Bellin, chaostheory.digital.
Josh is great cameras. The reason you can see all of my imperfections in my skin right now.
Lots of cameras.
Thank you, Josh.
Lighting, lots of microphones. So thanks, Josh. So we've been texting about this transplant story amongst the hosts and our group, but I feel like it's pretty early. Like a lot of stuff is shoes are going to drop.
Wait, when did that New York Times story on Philly come out? Was that today?
The New York Times.
Okay, so that's pretty recent too. That's the Philadelphia, same problem, same scheme almost, as to somebody in there messing with the criteria for a specific transplant in order to disqualify everybody on the list and get the right person there. So it sounds like almost as if your female 18-year-old co-ed is about to go row crew for Stanford's men's team. It's like a pay-to-play type scheme, it sounds like.
Oh, okay. Yeah, that's the thing. It's like, where's the incentive or the motive or
what? I'm guessing, in my opinion, for defamatory purposes, I'm guessing that would be I can't imagine any other reason why somebody wouldn't do that other than just pure, like the Dr. Death guy.
Yeah,
up in Dallas, who's just like in the business of paralyzing his best friends.
But you're thinking possibly, in your opinion, that they're trying to structure it to where a more favored patient would go higher on the list than a lesser favored patient.
I can't imagine why otherwise this would be a thing.
You always got to follow the money.
Yep, it's always about the money.
Okay, so I think Herrick has given us a very good idea about why med-mal is challenging. That was the thing. I mean, Bill, you probably get it. We would probably get most calls were med-mal type calls at my old firm, and you just, unfortunately, you're like, can't do anything to help you.
I have a handful. So we're going to trial next month.
Oh yeah,
in Harris County on one. It's a kind of brain dead baby delivery case. So our life care plan's like $70 million.
Yeah,
other than that, it's hard to. I mean, we're very picky because of one. The biggest deterrent for us is the caps, yes, but also all your experts in those cases are doctors, and doctors are super proud of their hourly rate, right? So to get them to not only be a part of it and come in on a med-mal case, usually they're from out of state, because in Texas, you never know who's going to be on the next review board. And so you don't want to make an opinion that's bad for a doctor, and then all of a sudden you go out for review and that doctor's sitting on your panel. So usually it's out of state and it's very expensive, not only just to get that report, but to get them to testify and all everything that goes with it. From my perspective, way more than I do about it.
Oh, no, I completely agree. And then when I think I mentioned earlier, trial settings, if I didn't, trial setting, whenever it gets pushed back further and further, you're still carrying those costs. You get a trial setting and then you line out a doctor. Once the doctor's lined up, they get that hourly rate up front before
It's a deposit, non-refundable deposit.
And you got to keep them happy because they got to make the next trial setting.
I saw the Texas Supreme Court is trying to help us a little bit, at least in Harris County, on getting trial settings.
You talking about the mandamus?
No, I'm talking about the judicial ethics opinion that came out that said, hey, judges, I'm not going to name which judge it was, but we had another, not the first in Harris County recently, but another one that said, hey, do your job. Start trying cases and setting them. Stop sitting around.
And it was really ruling. The issue was delays and rulings on
it was to sit on a summary judgment for 2.5 years. This seems like a lot.
Yeah. Yeah, you're right. That's a good point. I mean, that's one thing I talk about in mediations with plaintiffs is it's an inefficient system where you'll be set for trial and you think you're set, but you're two and lawyers all spend all the money getting experts and everything lined up. And then the judge says, sorry.
For the most part, these doctors that you're doing med mal cases with, they don't give. This isn't extra money. This is vacation money. Their real money is in their practice. So they're less understanding of changes and, oh, I don't need you here, because then you got, say you got a 2-week trial setting, you got to tell them what days to be there because they're usually flying in. They're not from Texas. And so it's like, come in this day and you better be on your game. Otherwise you're going to have to call them out of order mid testimony of a different witness.
My prior life wants me to ask this question. What type of limits do doctors typically carry? I mean, they're E&O, so they're going to waste, they're going to erode.
If you're lucky, they have 200.
1,000?
200,000? Yeah, they don't have to carry more. And then if you get to the root, it's typically $1 million.
What do I need to do to make chiropractors start carrying it? It's not required. Which is bullshit.
So you have a doctor that committed malpractice. You guys make a decision to file a claim. You're capped on the non-economics for that doctor at $250, and then up to an aggregate of $5, depending upon multiple providers. That doctor might carry a $200,000 wasting E&O policy.
It's where dollars to donuts. They're going to carry a 200, and then you get a group, they'll carry $1 million, and then that's why we have a saying: is it a doctor case, doctor only case? If it's a doctor only case, that goes into the full equation as to whether we're going to take it or not.
Can you stowerize the 200 against the cap? Since it's beneath the cap's the high, but they've got a limit that attaches beneath the cap?
It's a consent policy.
So the cap,
you get the double whammy at the end where the carrier may say, we'll pay the 200, and the doctor says no, because of the reporting issues.
We have at least one listener that's not a lawyer. It's my mother, Yvette Ogden. So when we're talking caps, can you explain what the caps are and what they apply to?
Well, it applies to the non-economic damages, which would be the pain and suffering, mental anguish, and so forth, not the medical bills or the future medical care. So,
how are they getting away with only $200,000 if their futures could? I mean, if we're taking a case, it's going to have big futures. For the most part,
it's capped. You're talking about the non-economic, the pain and suffering, and so forth. That's capped.
No, but if I've got a big life care plan, and the doctor's only got $200,000 in coverage,
then you don't take the case. You're never going to get there. I mean, if you're talking about it, the dollars don't make any sense.
And that is what Texas Congress people do to help the citizens of Texas.
Who writes it? Texas Medical, what is it?
TMLT?
TMLT. They write a lot of them, but there's a couple other ones. So that's why if you get the facility, then...
Yeah, you can own a building.
Yeah. So if it's a nursing case, if any nurse was involved or anyone other than the physician, then the facility's policy kicks in.
So the nurse is vicarious, so you could sue the facility for her negligence or his negligence.
Correct. So in the instance of Memorial Hermann, the nurses are non-UT for the most part. So if a nurse had an error in the med center at Memorial Hermann, then it wouldn't be a Texas tort claim then.
Is that just med center? What about Katy or Memorial?
If it's a UT physician that's actually working there, typically it used to be just the med center. But I think in the past, and don't quote me, a couple of years,
they got some money.
They have UT physicians that actually went out to Memorial City. So if you look it up, it's UT physicians. If it's not a UT physician, then you're good. You won't find a non-UT physician in the med side.
I tell you, as a new guy that would think, I know I got to get a qualifying medical report. I've read Chapter 74. I went to a CLE. I'm all about it. I would have not known about at all.
I wouldn't either. I didn't know that.
And that's gone, right? Once the 6-month notice period, it's gone.
Unless it's a constructive notice, that's the only thing that you have hanging. And if that happens,
Constructive notice is easier. I feel like with the Texas Tort Claims Act, when we talk notice, you have 6 months to give the government entity notice that that there's an injury involved and may be litigated. But with the med mal side of it, they kind of know, especially if you leave with a problem. Right or no, when you're experienced?
you would guess, you would assume. I mean, if there's a death,
Did anybody ever fight you on that issue? I guess.
Well, no, because the few ones that we've done where that's been an issue, we've had a not doctor only case.
Good. Okay. Wow, I just learned something that is going to change my intake.
Yeah. They're tough.
Thank you for that. Thank you.
It's like at these days, I mean, there's some cases that people can, be successful on, but it's you got to thread a lot of needles for that to work, and which is why probably
The problem
people
is
don't do them.
like from us, we're taking med mal cases, big ones, but at the same time, like I was overlooking that. I hadn't run into it yet, and by the time I do run into it, I'm in a place where I don't have anything to do other than put my carrier on notice.
Right. And then how do you prove constructive notice for a hospital because you've got peer review issues?
Right.
Yeah, it's completely privileged, barred. Even if you have it in your hand, you can't use it.
All right.
You got any good news?
Yeah.
Herrick, I didn't. Yeah, I had no idea. I didn't think
So, Herrick, you are a citizen of the United States and also France. Is that right?
No, that is.
So, were you born in France, or how did that come about to have the French citizenship?
I was born here. Both my parents are off the boat, so to speak, from France. And I just got citizenship from them.
Good.
So
What brought them here?
my mother's stepfather, he was working for Texaco. He was a geophysicist, and he was working in Libya back at the time of the 60s. And so that's where my parents met, and he moved back, so they followed with him.
Got it. Okay. And then grew up here
Here in
in Houston, college, law school.
I went to A&M and South Texas College of Law.
All right. And then when you got out, where did you go to work from law school?
I started at Mithoff Law Firm
Good.
with Richard Mithoff. I was the first one he hired straight out of law school. It was one of those things where he thought I was a hard worker, but the truth of the matter is my car didn't have AC in the summer.
So you're just enjoying the AC.
Early before anybody else got there, and I had to leave after everybody left, so it wouldn't be too hot. It all worked out.
So was it Midoff Jacks at that time, or was it Richard?
Midoff Jacks.
Okay. And then Tommy left, and then it was Richard and Bill Stradley and
Joe Alexander and Sherry Beckman.
got it.
Jordan.
Good. Well, how long were you there?
I was there for 13 years.
All right. But what was the time period?
I was there from 2000 to 2013.
And so you're doing, Richard was still doing med mal back then.
I
Still probably does some now too.
I cut my teeth on med mal that back when it was before the big tort reform. It was 4590I, and then it switched to Chapter 74.
Was that 2005?
For 2002.
Two? I thought it went in.
Then 2003, I think it went into effect. Yeah, it was HB4 is what the House bill was.
So you kept at it even after that, and
Did.
and then but obviously the firm had other major cases besides med mal cases.
They did. The Katrina bus case, a lot of it was Fort Firestone ending around that time period, and what else? A lot of products liability cases and personal injury premises, you name it. He did it.
Were you on that Katrina bus case?
I wasn't. I handled some of Richard's Fort Firestone ATX went on his tire rollover stuff as a baby lawyer, but Richard's reputation was one we didn't have to mess around much with his cases. He could kind of roll in with his notebook Hammond's the same way, and just kind of flip through and stamp and stamp and stamp, and we has done away.
Yeah.
Yeah.
And write the check.
And it was some efficiency brought to things based on reputation.
Yep. Okay. So when did you left Richard? 2013?
2013.
And what'd you do?
I went with a buddy of mine from straight Jesuit way back when. He was actually working for Morgan Lewis, and we just decided that we were going to start a new firm. He had a good client that did corporate work, corporate compliance. I never knew anything about corporate compliance, so I thought it was a good opportunity, along with maintaining my civil practice, and was there until about 2015.
What is corporate compliance? Because as a plaintiff's lawyer that sees nothing but corporations, I still haven't seen it yet.
Corporate compliance, in a nutshell, is making sure a company doesn't get in trouble by regulatory agencies. That's
God's word.
big global definition.
Okay.
And did y'all do international in addition to U.S.?
We did. It was international. We did a lot of work, a lot of traveling, and the time zones when that was before Zoom, we'd have video conferencings throughout the night and in the morning,
So
and so forth.
when it comes to, I don't know a lot of people that have dabbled or dabble in international law. How bad is the learning curve? Depending on where you're going.
Well, that's where we had other law firms that were
Okay.
specifically
In that country.
and within that specific sort of subject matter.
Okay.
So we didn't venture to learn a whole new law. It was we could digest from the specialists to come in, and they would tell us, we would ask them, this is what we need, and they could run it for us. We'd discuss and then process it.
Because I have a buddy right now who's running across the world right now trying to figure out what to do with Boeing right now. And so,
For Boeing or
no.
to Boeing?
Well, I guess technically on behalf of Boeing stock shareholders on, hey, because different countries are different. Like Germany, they don't mess around. Like in Germany, if you have a corporation, at the end of your calendar date, if you don't have like 20% of your liabilities in cash in your bank account, your entire board of directors goes to prison. Like hard rule. Like, so, I mean, the United States justice system is very different from a lot of different places. And so that's why I was curious. And he got his hands full right now, obviously.
What? But that's not the compliance part. That's the litigation part, which would be...
Well, he's on the compliance part on, serving maybe not so safe airplanes to different countries, because a lot of airlines are owned by countries outside the United States.
So they will trade on any of your heritage with Total and Technip and Air Liquide and French companies here in Houston?
Airbus.
It's very interesting. That's funny. Large companies like large law firms because it's their comfort zone. So, me having just a couple lawyers, they're not going to, just liability-wise, if something goes wrong, whoever picked us is oops. Yeah. So they like the comfort with the large numbers, large names.
So the clients you'd have here, like if they had something in, I don't know, South America, they're hiring you to then go hire the South, whatever country, Colombian lawyer in the oil and gas space to figure out how to...
Oil and gas based.
Yeah.
Pete.
I'm trying to be...
Colombian oil and gas, booming industry.
Yeah, whatever. Generic.
When I was doing that type of work, not the litigation aspect, that's essentially correct.
Yeah. Okay.
It would be essentially us managing the legal work and regulations in order for them to set up the standards and controls, put a program in place so they don't get in trouble.
And are you still doing that now, that kind of work?
I'm not doing compliance work anymore. It's 100% litigation.
All right. And what kind of stuff? What are you working on these days?
Well, we're still reviewing medical malpractice, personal injury. We still have a solid stable of car wreck cases and, slip and falls and so forth. We're doing a lot of commercial litigation. That's that dealing with real estate and business divorces, disputes, one owner stealing from another one. 50/50 LLCs are bread and butter.
Really?
There is that's the worst thing anyone can do. They're all friends. Join out 50-50. And if there's no safeguard.
What's the safeguard? Because we got to figure out a contract for this podcast at some point.
Yeah.
Well, safeguard can easily be a 50-50 split the revenue, but then you have a 49-51 vote, so you're never deadlocked. When you're deadlocked, you got to go to court.
People got an 80-10-10 plan, and these anyway. So yeah, other words.
Wait, Kyle's getting 10? I'm only getting 5. What?
Well, we're going to talk to Will after that. That's good to know. Okay, so if you're setting up a business on LegalZoom, do not do the 50-50 LLC.
Don't set it up on LegalZoom. I think it's yeah. You love it as much as their customers.
Yeah.
And probate stuff. I know you said you were doing some of that.
We are. I have an associate who's pushing that area of practice, and for whatever reason, we're just getting a bunch of referrals for probate litigation matters.
Is that
I got some right now.
Fights between beneficiaries of an estate or something else?
Or just setting them up, or
No. Well, they're setting she sets them up, but also what we do is, for instance, if there's an administrator who is, in our opinion, not administrating the estate properly, when it's a large estate, then we can have him or her removed. Secondly, we have a couple of them where, daughter, stepdaughter, aunt, uncle takes a person who's elderly, who has money, who has retirement, and
takes advantage.
Has dementia. They have them sign new POAs. They go ahead and have them sign a new will.
The old Anna Nicole Smith. Allegedly
scaled, so to speak, but yeah, it happens more than you would think.
So, other than being smarter than me, how'd you get comfortable getting so far outside of a wheelhouse? It seems like you don't have one, and you're doing a lot of different stuff.
We are fortunate to do a lot of different stuff, and I think being a smaller firm gives us the luxury of doing that. So we're not pigeonholed into, say, we only do car wreck cases. Being able to do that, we consistently learn. I mean, it's a law practice. We just learn as we go, and the knowledge we get even from these discussions just is great.
How many lawyers are you?
We're 2 right now.
Okay.
The probate skills you have. I remember I got a wrongful death case in Travis County that was in probate court, and it blew my mind. Didn't know how it worked, didn't know how it was there, thought it was misfiled. But apparently that's a thing. And I talked to someone recently about filing a case there, and they're like, it is skilled probate needs. You better have a probate lawyer do it with you. You can handle the blood and guts, but you can't handle the probate. So have you looked at venue as an option with your probate skills to file wrongful death cases? We have a new probate court here, don't we?
Mm-hmm. Hey, it's concurrent jurisdiction.
Do you file wrongful death cases here in probate court?
I do it all the time.
On the judges.
Yeah, 100%.
Depends on the judges.
It's not forum shopping. Texas Supreme Court.
You definitely need to have a local practitioner who knows those courts and the associate judges, right? The associate judges of probate court do a ton of the
They do a ton of the legwork. And actually in Harris County, the system is actually really good compared to some other venues that we won't.
We're going to talk about Brazoria County right now.
You file death claims in Harris County or just in Travis County probate court?
I filed death claims in Brazoria County, actually. Because I looked at my district court judges like, whoa. And then I was like, allegedly. Yeah, sometimes. Did I forum shop back then? Yes. But do I now? No, Texas Supreme Court. No, that would be so unethical.
All right, a couple things on probate, because we haven't had a probate lawyer ever. We've been wanting to have one, but you got one coming. We've got Mr. The Swiss.
She meant good.
But let's talk about that. So you've got dependent administration and independent administration. As I understand it, if you have a will that appoints someone to serve as the administrator of your estate, that's independent, meaning independent of the court. The court doesn't get involved in that lightly gets involved. Is that right?
Yes and no. If there's a person appointed through a will, they're an executor.
Mm-hmm.
And so they're not an administrator. And an administrator is appointed by the court if someone does not have a will.
Okay.
So if there's a will and there's an executor named, then, it can be as easy as just filing, opening up probate, having a few things just basically rubber stamped and it closed. No problem, no issue. It all depends on how prepared someone is. If they die without a will, then it could be sort of messy. Depends on whether you want an independent administration or a dependent. And then whenever we would file wrongful death claims or have a wrongful death claim, we would have a probate lawyer sever and apart who would then ask for a dependent administration so the court oversees it, and we have to get approval for certain steps.
The executor, so that litigation you're talking about, that would happen if the executor, someone didn't feel like the executor was following the will of the will's terms. That'd be one of those.
That could be where there could be a beneficiary that could...
I was supposed to get the car and they didn't give me the car.
Well, right. They gave it to someone else. Then that would be an issue.
And then how about on dependent? I mean, everything's going through the court.
Dependent administration, everything gets, you have to submit it to the court for approval.
So what's the type of litigation going on there on those that y'all get hired on?
On those, we have one, well, as an independent administration. Dependent administration is kind of hard because the court does actually, you have to present it and serve everybody with certain items that might get approved. And so if somebody has an objection, they can voice their objection prior to the court ruling.
I think there's going to be a ton of this because we're about to have the greatest wealth transfer in the history of the world coming up.
Oh, you mean when Donald Trump signed that socialist package and gave everybody $1,300 for COVID for no reason?
Is that one? I think that was the first. That was the greatest. We're about to have the second greatest.
Poster child of socialism. The largest socialism package ever came from Donald Trump.
All the baby boomers who have done very well are all in the process of passing away and handing off their money to their heirs, right?
You talking about the era that kind of ruined the country?
The what?
I said, you talking about the era that kind of ruined where we are right now?
You mean the greatest, the baby boomers, you think?
Tell that to every time I pay into Social Security, because it's going to be there when I get there.
Apparently that is happening. It's what it was called the Great Wealth Transfer. That's happening. So they're ahead of the Great Wealth Transfer is the people that are the Great Wealth steal, right, from the people that are taking advantage of people with Alzheimer's, dementia, that kind of thing. So you see a ton of that, and you get called on a lot of those cases.
We see quite a bit of it. More than what we'd like, honestly. It's one of those things where the cases it's just a sad situation. And the person who, we have to get sometimes personal like independent guardians or temporary guardians over the elderly person, take away the rights for them to actually sign off on the bank account.
How's that go over?
Yeah, I was going to say
That'd be a tough conversation.
A little emotional.
With everyone involved.
Well,
because just from the implication that comes with it.
Well, if they have dementia and they don't know.
Well, I just meant with like the rest of the family that doesn't have dementia, then you got to be like, wait, I'm not doing anything.
Whenever that happens, unless everybody agrees to it, there's always going to be an issue. Who's going to be appointed? Why is it this person over this person? And then, you have to fight over that before you even get to the next step.
Well, when we get done, give me your card because I got a bunch of cases. We settled a mass tort and I got a bunch of dead people now. It took too long. So
is it typically hourly type work?
It is typically hourly. It's not contingency. We don't take them on a contingency.
Yeah. Are there any ethical rules against that, like in family law?
I don't know. I think it's, I just think it's sort of bad form.
Yeah.
So not knocking anybody who does it. I'm just saying for my own personal preference, just, not taking a piece of the pie when, they're in a dispute over a piece of, from someone who's, not all there.
And so, Bill's going to get your card, but for the rest of the world, how can they find you online?
They can find me by Googling my last name, Sovany, or my website, SovanyLaw.com.
SovanyLaw.com. All right.
Right.
Very good. Okay. Well, thanks for that. We're going to transition into Will's story. So, Will, you apparently were one of the most watched videos or whatever.
Celeb dogs, celebrity guests. Celebrity guest host.
And so, I've talked to a lot of people, including lawyer I mediated with today, who had watched that and had really picked up a lot of interesting things from you and was
the stint past mess.
Yeah, that was it. That was one. And the prejudgment.
I'm getting hot flashes just sitting next to you.
No. So yeah, you're having an impact. So
Good.
you were here right on the following your departure from defense world into plaintiff's world and getting up to speed. Well, since then, you've had your first taste of plaintiff's victory, I understand.
That is right. So yeah, I was here 2 days after opening my place on March 1st. So it would have been 2 days after that, 2 work days after that.
Now he drives a Ferrari.
I don't. Ride with Ryan's on order. His passenger seat and his, I guess.
Yeah.
Same thing.
So I think you asked me, Bill, and Kyle might ask, are you hitting the road or are you hitting the ground? What are you doing? And I know. I'm like, I'm out there. People know who I am. I got to have lunches and dinners and drinks and introduce myself and remind them what I do. Plaintiffs Bar, incredibly receptive. Some folks...
You're welcome for that. That was all me.
Appreciate it.
That was all me.
And Peter has actually been a great help.
They hated you until I was like, guys, no, he's good. I promise.
This podcast helped, and it's I'm grateful to be on it the first time and to be back. But I kind of sold to folks a mercenary role, that if you got something to try and you're jammed up and you can't do trials, you want to keep a trial setting, talking about your commentary earlier about getting there. You don't want to get there and not be able to get there. So I've had some folks reach out and say, hey, can you try some stuff for us? So Abraham Watkins, Moses reached out and said, hey, I got this conflict. I trust you. My client trusts you. He wasn't phoning it in. He said, hey, you're going to give great representation to my team, and we need that. So I utilized his staff, and then I tried it with one of his colleagues, Michelle Rice, who's great. You came in, parachuted in as that concept goes, like I did as a defense lawyer, did it as a plaintiff's lawyer. And
I'll say it like that.
Went to Pegasus Division. The insurer offered $8,500 US. The defense lawyer anchored a trial, having thought they won the case at $4,000 US. $4,000.
Okay.
And Will, embracing appropriate reptile techniques, convinced a Pegasus Division federal jury to give our client $1.5 million. So.
I had two things on that. First, huge, kind of nod that Mo would say, hey, you're my call here.
Yeah.
Because I don't think any trial lawyer, especially at his level, is going to want to just give it away to just anyone. Second of all, how many times prior to this trial have you objected to the reptile theory being used in trial against you?
I never filed the goofy lemonades that people file.
Okay, I was just making sure.
Yeah, no, I think reputationally, I think credibility matters. I never filed. If my team filed, I withdrew them at pretrial if I went to pretrial. Oftentimes, I didn't go to pretrial. But I didn't do that fight because that was silly. I'd make a proper objection, see what happens. But in this case, I remember in closing, embracing reptile theory. There's, outside of Pecos, there's the U.S. highway they call the Highway of Death. And I reminded the jury that with their verdict, they have an opportunity to change the name of the Highway of Death. And it works.
Well, Harris County just, as of a week ago, we now have the Highway of Death.
Yeah, and that was
Which one?
45 from the Woodlands to Galveston is statistically the deadliest highway on the planet.
Wow.
Yeah, but it was fun. I mean, I emotionally get committed to the case, and I was a defense lawyer. I was going to fight fair, but I was going to try to win. In this case, I felt sorry for this guy. The insurance company screwed him over. That's reality. If it has companies watching, they did. So what I did, I looked at Mo's file and said, y'all wrote a good style, but I'm going to write a different one now because it's tight. And I literally, in 5 pages, the drinking game is every time Will touches the table, you have to.
Yeah, I drank.
But I rewrote it, and Mo was awesome. He's like, do what you want to do. You're an insurance guy. And I essentially said, dear insurer, although you write it to the insured, you don't write it to the insured. Dear defense lawyer, I like you. I trust you. I know your firm. I've read your reports when I've been co-counsel. I've read your reports when I was excess and you were primary. So I know you didn't make this mistake. The insurer had to be hired behind this technicality, which we'll now fix. And then let's lay it out. And I said, this is what's going to happen if we try this case and you don't settle with us. And it literally happened, all of it. And it was a little baity. It's like, I know you're not going to do this, but if you do it, this is what's going to happen to you. And they did it. And, you know, I when I parachuted into cases, it was always kind of, I guess it's relevant for a recent death. But I always said, as a lawyer, don't be Chris Darden and find a Mark Furman. That's the 2 things I always try to do. And the Mark Furman could be a doctor, it could be anybody.
In our case, and I won't give you counsel's name, in our case, defense lawyer was Chris Darden, and he turned out to be my Mark Furman because it was a guy in a straight roadway gets slammed. I mean, 60 mile an hour, Delta V's in the 40s. So it was a big rear ender. Yeah. But our problem, 10 days of treatment, 14 months off with literally 2,000 hours of TikTok videos. He's out on the field welding. He's riding jet skis. He's traveling to Vegas. He's dancing. He's falling down, literally drunk on TikTok, having the time of his life. I'm not saying he wouldn't hurt. I'm not saying he didn't need what he needed. The doctor said, get it, he got it. But that wasn't my fight because I was taking the facts I had then. And I was praying they were going to blame this guy, and they blamed him for reasons I don't understand.
On the liability side?
It tried to the liability side, and then the driver, the defense driver, nice guy, preacher in Kermit, Texas, in the division. I couldn't blame him. I couldn't attack him. Business owner, nice guy, couldn't really attack him, so I couldn't find my Furman. But they cooked up this story about he reacted to a right turn all of a sudden and then had no time to react with no recon. And I thought, okay, well, that doesn't make any sense. And then it was a hill, and it was a blind curve, and there was this and that.
No recon, no accident recon.
No accident recon. So they took a recorded statement of the guy, their driver, 4 days later, and his story changed when he was deposed. Again, I didn't blame him. They answered interrogatories. Well, first off, they did an affidavit for the company about supporting a summary judgment, how he was intimately involved with the investigation. So I'm like, all right, well, y'all didn't do anything. So I'm going to prove up some attribute. What'd you do? Did you have a seminar about it? Did you have a stop work? Did you have a lessons learned? Did you have a near miss? It wasn't a near miss. What did you do? And I knew he wouldn't do anything. So, but I was going to lay the foundation of, you swore to this judge, not the jury, you swore to the judge that you knew everything. He's like, I've never seen that before. I'm like, when have you seen that before? You've never seen this affidavit? You swore to the judge that you were competent, knew all the facts under oath? I've never,
Above 18 years old?
never seen that. Okay. Well, let's talk about your interrogatories. Interrogatories, comically answered. Okay, well, you told me this under oath. Well, I don't know. I don't know what you're talking about. I never told you anything. I'm here today. I understand. Interrogatory, lawyer word for question, your answer, sir.
No.
Never seen it.
Here's your verification page.
So you swore under oath these things? You've never seen it? No. Who wrote it? Your lawyers? I guess so. So these are your lawyers' answers, not your answers? That's right.
So found him. Not your Furman.
Found my Furman. My guy then has 2 Social Security numbers because he's earning a living and he wasn't legal to work. So they raised holy hell for 2 hours about, you're a fraud because you got 2 socials. You're a fraud because you got 2 socials. You don't tell the truth. You'll lie to the government, blah, 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 blah. I got him to admit, 1, you pay taxes. 2, you pay Social Security taxes you'll never get back because you can't participate in it.
That's all of us under 40.
Yeah, so he's done. Exactly. Yeah, the great exchange of money.
Yeah.
So, it was, you're not, and I told him in the demand, this is what your lawyers are going to do and it's not going to work. So my closing, I said, look, if you got a credibility concern and you got a coin flip and you got to decide, who do you trust? You trust the man who falsified a government document to feed his 6 children, or do you trust a man that falsified documents to win a lawsuit? And they bought it.
And that's when we knew Will Moye was a plaintiff's attorney for life.
Yeah, so you'd posted on your on social media that defense took a tack that you didn't think they would do, but hoped they would do, and they did.
Yeah, so I rolled it. I thought it was good for the client. I thought it was necessary for the client not to, that 3 weeks out, not to lay back on a trial strategy. I thought it was, if we can get a good Stowers to force these yahoos to doing what's right, then let's write it. So I wrote it with a roadmap, hoping it would encourage them to realize maybe the reporting's not up to snuff. Maybe, like we talked about last time, maybe it's a defense lawyer that's misread the facts and has reported the facts the wrong way and ensures hide behind those. Well, guess what? I used to do that work. I used to write these reports. Here's what they should be doing to you and telling you. And I'm telling you, this is what's going to happen. When they didn't accept the Stowers, I thought, well, man, did I screw up by putting my playbook out there? No, because if they try the case the way they should, all right, we'll just try on the medicine. If they don't, I'm going to try it against the lawyer. And that's what we did.
So how did it break down on the damage award?
I don't remember. I just wanted it to be more than $4,000.
Well, yeah. So I don't know if you can disclose, but I assume you busted the policy?
Yeah. So with interest, it's going to be about 1.9. So they had a little policy, a little property erosion. So there's a little less than $1 million left. I talked to their adjuster today, and I'm getting a little bit of chatter of the limit.
And I thought, well,
Better go Tesla truck shopping.
yeah, well, again, I didn't ex parte the guy, but the defendant was down the whole time. The driver wasn't sued, the preacher. But the company man, not as an oil field term, but the owner of the company, nice as could be. And I knew right then, man, I can't attack these two or I'm going to get smoked. I'm an out-of-state, out-of-city lawyer here. So I found my firm and by finding the defense lawyer to do it for me. But I talked to him after, and I'd said it in earshot of his lawyers and said, look, I'm not ex parteing you. I'm not having a conversation behind their back. But you got screwed by your insurance company because I wrote them a letter, and they should have paid it. So you need to get counsel, and your lawyer needs to call me because I need an assignment. I'll give you a covenant not to execute. I won't chase a penny of your money. We need to do this together to go get the insurance company to do what's right. So we'll see what happens.
Okay.
First one out of the box.
Look at that. I mean, I feel like we saw each other yesterday and you were still us as the defense bar. And now you're like, yeah, I'm stowrized blower. No, I'm shooting guns from the hip.
Well, I just know when I got a style, like I literally wrote it. The last paragraph says, I've looked at your stuff. There's not a defense lawyer in town that wouldn't recommend this is a limits case. I know you did. And I know this insurer's hiding behind a technicality. That no longer exists. But I was wrong.
What city was defense from?
San Antonio and Albuquerque.
Oh, why would where did he end up having surgery or what? Obviously, the liability side was.
Yeah, so our fight was a big delay in treatment, which is never fun to deal with. A big delay in treatment with massive amounts of surveillance and massive amounts of self-surveillance via TikTok and others. The TikTok was bad. We were on a timing order of federal court, so they couldn't show a lot of stuff. They showed enough. They called their investigator to prove up the surveillance because I wouldn't agree to it as a hearsay doc.
Did they produce it all?
They did. They produced it all, but then they called their guy to prove it up. So what did I do when they called their guy to prove it up? Okay, I got your timesheets. You're out there for 100 hours, right? Yeah, I got 1 hour of video. Where's the other 99? What was he doing the other 99? So when your members only jacket, you're spying around a corner, spying on them. At one point, he filmed him dropping his kids off at school and then picking his kids up from school. And I raised hell about that. Spying. So the bad surveillance got offset by not doing it right. And then if they'd just tried a case straight up and down on causation on the medicine, it sounds arrogant. Don't mean it to. If I was a defense lawyer, it would have been a 0. I just believe it.
Maybe 4,000.
I think I'd want on causation. I really do. So, and we had problems. We had a billed laminectomy in addition to the fusion. Well, someone looked at the CT after my guy left, so I couldn't call him back. And their doctor said, hey, by the way, I looked at CT. There was no laminectomy done. But we billed for it, and he owes it, and it's not there on CT. So
it's called a bad fact.
I would have led with that fact, not buried that fact. I mean, it was at the end. And the jury by that time is already either committed to being picking a team, and they didn't care. But that's a fact that should have been, oh, by the way, Mr. Moye's talking about how this client owes it, and he owes it. Well, I'd have seized on that fact immediately and said, well, he owes a surgery that his doctor didn't even do. And I don't know if he did or not. So, again, for the purposes of defamatory commentary and other things.
In my opinion,
no.
Will says, in my opinion, this.
Because, the problem is, too, the one thing they did do well, I would have probably asked the doctor I had up. They saved it for their guy live. And then he shows the CT and says it's not there. What the hell am I going to do? Get the laser pointer out and start debating the doctor whether laminectomy?
Ying and out doctor.
No, and it's just kind of sink, cross your fingers, and hope nobody picked up on it. So, but yeah, first was out of the box.
As I'm sitting here, the more you talk, the more I'm thinking this is why Mo didn't want to try the case.
Yeah, this is a great result. Yeah, very great results.
So, Will, you mentioned something on Stowers, they're hiding behind a technicality. What are some of the technicalities you would see in Stowers demands that would render them ineffective, in your opinion, when you're on the defense side?
The biggest one is you have to have a demand made within coverage. And too often people look at the deck page, they look at the limit, they make a demand for $1 million, and then not know there's roadway cleanup that might have been paid. That's erodes the indemnity limit, property damage, another vehicle, who knows what other, another involved occupant. In our case, there was erosion because there was a lead vehicle that got hit that chewed a little policy, and then there was PD, property damage that chewed some policy. So I knew it wasn't $1 million. The indemnity had eroded. But It is, we make a demand within coverage for $1 million or available insurance limits. And without those 4 words, it's an easy no. And don't give those guys an easy no.
Yeah. And how can you find out what the remaining limits are? Because maybe someone goes, well, I don't want to do that because what if it turns out there's only 333 left? And now I'm stuck with, if they say accepted, then I'm got 333. So.
Yeah. Well, if that's all there is and there's no excess, then what harm is? If that's all they're going to be, it's all there's going to be. I think that under the Texas disclosure rules, I think that, 194? Mm-hmm. I think they have an obligation to tell you. I think they have.
I have been in a number of arguments that says that they don't have to tell.
I think they do.
I've won it every time when I tell the judge, but it's always multiple policies. So if we got a ladder, it's like, Judge, I need to know which policy I'm stowrizing.
Yeah. Well,
so that helps me. Yeah. But on a single, I've argued a bunch. I've won them, but not every single one.
I think they should tell you. I would hope that
y'all should tell
former colleagues on the defense bar would say, yeah, there's this erosion, because you need to know what we're dealing with anyway.
So much growth I'm seeing.
Yeah,
just on the language.
But if it's your client involved, ask your client, did they pay for property? Yes. How much was it? It's $1 million minus that. If there's another vehicle involved, you go to the police report, you can subpoena that, make a determination if anything was paid. So you can guess on the numbers, but if it's a fear of, I don't want to do it because it's massive erosion, well, you got Soriano. You should have been earlier in the ball game anyway.
Yep.
So I had a case last week that someone sent me and said, hey, can you take a look at it? And I looked at it, and I'm like, look, this is personal lines auto. I'm not taking this at a fee. I'll write a demand for you. And I call the adjuster, and she's like, yeah, it's, Texas's first come, and this is a 3-car accident, at Stowers in 3 hours and acceptance, the next morning, because Soriano would have said 0. So, that's a problem.
Yeah. How many jurors?
Well, he sat 8. The magistrate did voir dire.
In federal court?
Yeah. So the magistrate did voir dire and did 6 and 2. And we got 15 minutes to do voir dire after he asked the questions, which they asked some questions that were pretty self-serving because he read them verbatim. So it was fine. We went 6 and 2. We got ready to close and argue. And the judge said, you got 8. I'm like, well, Judge, we don't have 8. We got 6 and 2. You cut the other 2 loose. They're not obviously deliberating. They can listen to the show, but after that, they got to go home. He said, no, it's all 8. And I'm like, Jesus. And I had to look and I said, can I get a minute? Because I got to go look at my strike sheet, because I got to make sure that I didn't kill at 12 when I should have killed at 14 if I got 2 more to deal with, or 16, right? 3, 3, 6, and 8.
Yep.
So, yeah. Our gate was 12, the non-lawyers. They get 3 strikes. I get 3 strikes. We're going to sit 6. So 3, 3, 6, 6 is 12. So I know I'm striking through 12.
Assuming you don't overlap on a strike.
Which I thought we'd have a double strike for sure. I always have at least one. Not always, but often. But then I got concerned. I'm like, wait, where am I on the veneer? Would I have killed off one of the alternates in favor of who I did kill off? But I wouldn't have. And I was, what am I going to do? Be honest with the court. I thought we were going to win, so I wasn't going to move for a mistrial then. But I was candid with him and said, look, I don't think as we were told. I struck who I struck, but my gate was 12. I would have left the back 2 alone anyway, so let's roll.
So with an 8-person jury, you can still win with a 7-1?
I think he told him in unanimous.
Oh, okay.
Yeah, and I know the defense lawyer polled after, and it was unanimous regardless. But
did you talk to this jury now that you're a plaintiff's lawyer?
No, I don't want to violate him. I'm never talking to a jury rule ever again. I just won't. I won't. So I didn't.
Who's your colleague from Abraham?
Rice.
Did she talk to him?
I don't know.
You're keeping really straight to that rule.
I like it.
Yeah.
Man of principle. Well, different principles than you used to have, but same.
No, I just didn't want to be manipulated by one person that didn't like me. I think I got a personality. One of your former colleagues has a personality. Not everybody's going to love that, but a lot of people are.
Oh, you're talking about Kyle.
About Kyle, yeah. I had a trial, a Ford case. Xandra Foley tried it with me. During my closing, one of the jurors started to turn her back to me, and I missed her. We missed her in voir dire. She was in the Heights. She was liberal. She was bad anti-corporate juror. She'd never been there. We missed her. And I remember I sat down with this juror, halfway turned around, and Xandra leans over and says, you only need 10. So, and that's kind of my view of it. They're going to have a couple people who won't like me. That's fine. I don't want to change what I'm doing.
Good. Bill, got anything?
No. I've learned more from these two right now. One, on the stuff that I didn't already know. And 2,
I knew you were going to get here. I just didn't know you were going to be this fast as a plaintiff's lawyer.
I got another mercenary case, Southern District, Galveston Division, 2 weeks against Caterpillar on a products case. I got some old partners of mine to do Ford work together. So
Who are you,
I mean, it might be a challenge, though.
who are you trying it with?
Sestavaris' associate, Michael. So I'm going to go down and make it.
Good. He's a judge.
Big case?
Judge Jeff Brown.
Yeah. Who all accounts are, smart guy, obviously, district court bench, Supreme Court here.
Fair.
I've
He actually,
Thoroughly enjoy being in that court.
yeah, I've known him a long time.
and he's a federal judge, sure, but he did enough trial work where he didn't have that type of federal judge attitude. Often creeps their way into the black robe.
Yeah, he is a really good guy. I think he'll like trying a case with him. And yes, Seth is trying some case in California, I think, right?
Yeah, he's in California, so he called and said, "Hey, I'm in California. We got 3 hours a day. I'm going to be out here a month and a half. We want to keep a setting. We don't want to move it. I got a good client. He'll like you. Interview him, see if you like him. He likes you, and if so, go get him." So we're going to go get him.
Good. Okay, when's that said?
13th.
Because that's the beauty of federal court is you go to trial. Yeah.
And as soon as you say hi, the timer starts.
Yes. Yeah.
All right. Well, good. Well, Will, since we've got Kyle on probation and one more miss and he's out.
Yep.
So
He's on triple probation right now.
Yeah, so good. So thanks both y'all. Hopefully, I think that, again, we've just had my brain's a little overworked because we had two very substantive.
Yeah, I think it's just age. It's just age.
That too. But no, this is very informative from both of y'all, so I really appreciate y'all coming on. And so, Bill, unless you've got anything else?
No. Are we going to roll out and then roll back in?
Why don't you do the rollout?
Oh, man, I'm terrible at this. Thank you for listening to our two esteemed guests. If you would like to follow us, you can find us on YouTube, Spotify, Instagram, TikTok, Apple Podcasts, or anywhere else you find your podcast. You can find The Dirty Verdict. And friend request Peter on social media. He loves to make fun of you if you friend him.
It may or may not be true. Thanks a lot for joining us. We'll see you next week. Thank you.
You asked for it.
All right.
I got